Karachi, the Sindh High Court (SHC) on Tuesday issued a notice to K Electric K Chief Tayyab Tareen on Wednesday in a contempt of court application pertaining to unannounced load shedding, until May 30th. A two-member bench headed Justice Hasan Azhar Rizvi was hearing a contempt application moved by Karamat Ali and others seeking compliance of court order. Petitioners' counsel Barrister Faisal Siddiqui submitted that hours-long unannounced load shedding has troubled the citizens of Karachi. He pointed out that the Supreme Court in 2014 had directed the power utility not to resort to load shedding in Ramadan, and the K was violating the apex court's order by still carrying out load shedding as major parts of the city plunged into darkness during Sehri timings, and the NEPRA is avoiding to take any action against the power supply company. Barrister Siddiqui argued that the K did not increase its production capacity as per the agreement. The petitioners submitted that over 1,000 people lost their lives and over 40,000 people were affected by the heat wave in Karachi and other parts of the province in 2015. They sought enforcement of the fundamental rights and the law for the victims, the survivors, and their families. The petitioners pleaded the court to issue direction to the provincial and the federal government to provide compensations to the heat stroke victims, and declare the heat stroke patients were entitled, as a fundamental right under the Constitution, to demand an appropriate compensation from the government. He added that the residents of the metropolis have fallen victim to unprecedented and sporadic power cuts as K and the Sway Southern Gas Company engage in a war of words over a low supply of gas to the electricity provider, which has impeded the provision of electricity to consumers. Earlier, the court had expressed grave displeasure over the failure of the National Electric Power Regulatory Authority (NEPRA) to keep a vigilant eye on the power utility's alleged malpractices. The court had observed that NEPRA seemed to be not willing to take action against the power utility. Petitioners' counsel in his arguments had submitted that the power utility was legally bound to provide electricity to the consumers without any discrimination. He argued that if there was power theft by some consumers in a locality, the whole population of the vicinity should not be punished by resorting to load shedding to minimize the KE's losses. Advocate Siddiqui said that the K, instead of taking action against the power thieves, was carrying out load shedding to minimize its losses. Page 2 Lahore. The Lahore High Court Tuesday issued notice to Pakistan Electronic Media Regulatory (PEMRA) on an application against the authority for its failure to stop television channels from airing anti-judiciary speeches despite court order. A full bench headed by Justice Syed Mazhar Ali Akbar, Naqvi, was hearing the case against alleged anti-judiciary speeches and a rally taken out against the institution of judiciary in Kasur. On the outset of the proceedings, petitioners' counsel Azhar Siddiqui said that the court previously had directed for the compliance of the PEMRA laws, but the order was not obeyed and alleged contemptuous stuff was continuously being aired against the superior judiciary and its judges. The counsel said that the PEMRA did not play its due role and it violated the court orders, which is tantamount to contempt of court. Azhar told the bench that Nawaz Sharif recently gave an interview to an English daily and his interview was against the interest of the state and fell within the meaning of treason. At this, Justice Naqvi, who was heading the bench, observed that it was completely a different matter and had not been pending before the court. However, the bench observed that the petitioner could move a separate application to this effect. The court issued notice to PEMRA on the application moved by Civil Society Network President Abdullah Malik seeking action against Pakistan Electronic Media Regulatory Authority (PEMRA) for allegedly violating the court orders regarding its failure to control airing of anti-judiciary speeches. During the proceedings, PMLNMNA Wasim Akhtar, MP, and Naeem Safdar and other four accused of taking anti-judiciary rally in Kasur appeared before the bench and submitted written apology before the court. However, the bench pointed out several mistakes in the written apology, with directives to them to remove all errors from their written apology and submit again. Additional Advocate General Sean Gull could not appear before the bench, on which the bench expressed dismay, observing that it should be clear that no one could delay the contempt proceedings. The court put off further proceedings until May 24. Kasur police registered a case against over 80 persons, out of which 6 were identified as members of the ruling party PMLN. The police booked them under sections 166, 506, 341, 228,109, 147 and 149 of the PPC. Kasur District Bar Association President Mirza Naseem filed a petition submitting that the protest in Kasur was a planned conspiracy against the institution of judiciary. He alleged that the rally was led by PMLN's MNA Wasim Sajjad and MPA Safdar Ansari, while some local leaders of the unions also accompanied them. The bar leader said that by doing so, the protesters committed contempt of court and therefore they must be punished. He prayed to the court to declare the parliamentarian disqualified and proceed against them in accordance with the law. The same bench had been hearing the petitions against alleged anti-judiciary speeches of ousted Prime Minister Nawaz Sharif, his daughter Maryam Nawaz and other leaders of the PMLN. The bench was also seized with the hearing of petitions against MQM London chief for his anti-state speeches. LHC dismisses minister's plea against delimitation of 2 provincial constituencies. The Lahore High Court on Tuesday turned down a petition moved by Provincial Minister for Education Rana Mahmood Ahmad Khan questioning delimitation of his constituency. Justice Shahid Karim passed the order and directed the minister to approach the Election Commission of Pakistan (ECP) for the redressal of his grievance about the delimitation. Registrar Office had earlier objected to the petition on maintainability ground. However, the court had taken it as objection case and reserved the verdict on its maintainability. The minister in his petition had questioned the delimitation of PP 149 and PP 150 of Lahore, pleading that the ECP be directed to hold delimitation of the 2 adjoining provincial constituencies afresh in light of objections raised by the voters. Ends, May 22, 2018, FIDA.